Hello, everybody. Hello, hello. Welcome in. Welcome in. I do have comments off here because I would like to read through the decision that just came out here regarding the law firm. I think this is just an incredibly well-written decision, and so I thought I would just read through it. I've got comments off, but I will do Q&A and analysis after I have finished reading, all right? So let me just put that down here. We'll do Q&A at the end. There we go. Gives everybody a chance to just kind of listen to what's going on in the case. I will do my own analysis after I have finished reading it. So stay tuned for that. I do have my throat lozenges going, and then I also have my tea here. So we should be okay as long as I can just read it straight through. And then again, I will do a Q&A analysis afterwards. All right, so hopefully I'm in frame well enough. There we are. I'll go ahead and get started then, everyone. This is the Jenner and Block LLP case versus the DOJ out of the DC court. Here's the case number if you're interested in looking it up. This was filed just yesterday. Here we go. Memorandum opinion. In our constitutional order, few stars are as fixed as the principle that no official can prescribe what shall be orthodox in politics. And in our constitutional order, few actors are as central to fixing that star as lawyers. This case arises from one of a series of executive orders targeting law firms that in one way or another did not bow to the current presidential administration's political orthodoxy. Like the others in the series, this order, which takes aim at the global law firm Jenner and Block, makes no bones about why it chose its target. It picked Jenner because of the causes Jenner champions, the clients Jenner represents, and a lawyer Jenner once employed. Going after law firms in this way is doubly violative of the Constitution, most obviously retaliating against firms for the views embodied in their legal work, and thereby seeking to muzzle them going forward, violates the First Amendment central command that government may not use the power of the state to punish or suppress disfavored expression. Citing case law. More subtle, but perhaps more pernicious, is the message the order sends to the lawyers whose unalloyed advocacy protects against government viewpoints becoming government-imposed orthodoxy. This order, like others, seeks to chill legal representation the administration doesn't like, thereby insulating the executive branch from the judicial check fundamental to the separations of powers. It thus violates the Constitution, and the court will enjoin its operation in full. Background. Jenner and Block is a 900-person litigation-focused law firm with offices in Chicago, Washington, D.C., New York, Los Angeles, Century City, San Francisco, and London. Its clients span a wide spectrum. What's important to this case is that representing them requires frequently dozens of times per month appearing in federal court, entering federal buildings, interacting with federal employees, and the like. Jenner also has a leading and diverse pro bono practice, having been rated the #1 law firm for pro bono work by the American Lawyer. As a prominent law firm, Jenner is no stranger to executive orders, but it has had more experience representing their targets than being a target themselves. The Executive Order 14246 flipped the script, issued on March 25th of 2025, the title Addressing Risks from Jenner and Block. Executive Order 14246 took aim at Jenner, singling out the firm for disfavored treatment. The order wastes no time saying why. Its first section begins by articulating the president's view that many major law firms take actions that threaten public safety and national security, limit constitutional freedoms, degrade the quality of American elections, or undermine bedrock American principles, in large part through their powerful pro bono practices. Jenner, it says, is one such firm. According to the order, Jenner undermines the interests of the United States in three main ways: partisan case selection, pro bono representation the president dislikes, and past association with an attorney of whom the president disapproves. On partisanship, Section 1 accuses Jenner of condoning partisan lawfare by engaging in obvious partisan representations to achieve political ends. It does not elaborate. On pro bono representation, Section 1 accuses Jenner of supporting attacks against women and children based on a refusal to accept the biological reality of a sex and backing the obstruction of efforts to prevent illegal aliens from committing horrific crimes and trafficking deadly drugs within our borders. Aside from its vague reference to Jenner's powerful pro bono practice, on this too, the order is coy. In context, however, the order refers to Jenner's ongoing challenges to two other executive orders issued by the administration, one on behalf of transgender individuals and the other on behalf of asylum seekers, both of which have resulted in favorable preliminary outcomes for Jenner's clients. And on attorney association, Section 1 laments that Jenner was thrilled to rehire the unethical Andrew Weissmann. Weissmann, a former federal prosecutor, was a partner at Jenner from 2006 to 2011 and from 2020 to 2021. He's not worked there since. In the interim, he served the federal government in various capacities, including investigating Russian interference in the 2016 election as a member of the team led by special counsel Robert Mueller. Weissmann's participation on the Mueller team, plus his public criticism of the president, including per Section 1, his overt demand that the federal government pursue a political agenda against TRUMP, and his authorship of a nonfiction book critical of the president, has drawn the president's ire. And so Jenner's relationship with Weissmann is a concerning indictment of Jenner's values and priorities. Separately and briefly, the order accuses Jenner of discriminating against its employees based on race and other categories prohibited by civil rights laws, including through the use of race-based targets. Again, the order does not elaborate. An accompanying fact sheet says only Jenner has been accused of discriminating against its own employees on the basis of race and other categories. Like the order itself, the fact sheet does not provide any evidence of the accusations or of their truth. With the background set in the order's four following sections: direct action against Jenner, and with respect to security clearances in Section 2, government contracts, Section 3, anti-discrimination law enforcement, Section 4, and access to government buildings, personnel, and employment, Section 5. Section 2, titled Security Clearance Review, instructs the Attorney General and other agency heads to immediately take steps consistent with applicable law to suspend any active security clearances held by individuals at Jenner, pending review of whether such clearances are consistent with national interest. It also directs the Office of Management and Budget to identify all government goods, property, material, and services, including sensitive compartmented information facilities provided for the benefit of Jenner, and instructs agency heads to expeditiously cease such provision. The fact sheet makes clear that both actions are to happen immediately. Section 3, titled Contracting, seeks to end all contractual and subcontractual relationships connecting, however tenuously, Jenner and the federal government in order, quote, to prevent the transfer of taxpayer dollars, end quote, to Jenner. And then they're citing the fact sheet here: to ensure taxpayer dollars no longer go to contractors whose earnings subsidize activities not aligned with American interests, end quote. It instructs government contracting agencies to require government contractors to disclose any business they do with Jenner and whether that business is related to the subject of the government contract. With that information in hand, agency heads are to review all contracts with Jenner or with entities that disclose doing business with Jenner, terminate any contract to the maximum extent permitted by applicable law for which Jenner has been hired to perform any service, and otherwise align their agency funding decisions with the interests of the citizens of the United States. Section 4, titled Racial Discrimination, is a bit more opaque. It instructs that the order shall not be construed to limit the action authorized by Section 4 of an earlier executive order, one targeting Perkins Coie, another major law firm. That order in turn instructed the chair of the Equal Employment Opportunities Commission to review the practices of representative large, influential, or industry-leading law firms for consistency with anti-discrimination law. Of course, it would be difficult to read this order to limit any action against Jenner, so the fact sheet confirms what Section 4 really means. Quote, the practices of Jenner will be reviewed under Title 7 to ensure compliance with civil rights laws against racial bias. And then we have footnote here, number 2. The Perkins Coie order to which Section 4 refers has since been permanently enjoined. Finally, Section 5, titled Personnel, takes aim at every Jenner employee. It instructs agency heads to the extent permitted by law to provide guidance limiting official access to federal government buildings to employees of Jenner when such access would threaten the national security of or otherwise be inconsistent with the interests of the United States. It instructs agency heads to provide guidance limiting government employees acting in their official capacity from engaging with Jenner employees, including but not limited to Andrew Weissman, not a Jenner employee, to ensure consistency with the national security and other interests of the United States. And it instructs agencies to refrain from hiring employees of Jenner, including but not limited to Andrew Weissman, absent a waiver from the head of the agency made in consultation with the director of the Office of Personnel Management, that such hire will not threaten the national security of the United States. The fact sheet confirms, quote, federal agencies will refrain from hiring Jenner employees unless specifically authorized, end quote. According to undisputed evidence in the record, the order quickly had its intended effect. Department of Justice lawyers instructed a Jenner client not to bring its counsel from Jenner to a meeting with the Department of Justice scheduled for April 3rd. Many other clients have contacted Jenner with concerns about Jenner's ability to represent them moving forward, indicating that they will need to make decisions shortly about their retention of the firm. And more severe harms are in the offing. More than 40% of Jenner's revenue comes from government contractors, subcontractors, or affiliates. The order puts that revenue in grave risk. Executive orders like this one have become something of a modus operandi for the president. Both before and after this order, the administration trained similar orders on other large law firms, including Covington and Burling, Paul Weiss, Rifkind, Wharton and Garrison, Perkins Coie, Wilmer Hale, and Sussman Godfrey. Footnote 3 here is the citation. The orders follow the same recipe. Other than personalized touches in their first sections, they generally direct the same adverse actions towards each firm and decry the threat each firm poses to national security and the national interest. It will not come as a spoiler that Jenner opted to sue, but not everyone did. Paul Weiss, for instance, negotiated. A citation here. The negotiation ended in a remarkable change of course from both Paul Weiss and the administration. According to the president, Paul Weiss acknowledged the wrongdoing of its former partner, who, like Weissman, had drawn the president's anger, and agreed to adopt a policy of political neutrality with respect to client selections and attorney hiring, take on a wide range of pro bono matters representing the full political spectrum, commit to a merit-based hiring, promotion, and retention instead of diversity, equity, and inclusion policies, and dedicate the equivalent of $40 million in pro bono legal services, quote, to support the administration's initiative, end quote. In exchange, the administration revoked the executive order aimed at Paul Weiss. Other firms skipped straight to negotiations without ever receiving an executive order. These firms preemptively bargained with the administration and struck deals sparing them. The deals largely mirror Paul Weiss's, though the price continues to rise. Instead of $40 million, these firms have pledged $100 million or more in pro bono legal services. The administration has a hand in choosing. Footnote number 4 here is citation. And in public statements, the president has floated the prospect of deploying the firms to work on the administration's own projects rather than the traditional pro bono causes, while acknowledging the firm's lack of wrongdoing. Quote, "I agree, they've done nothing wrong," end quote. The president said at a recent event, quote, "But what the hell, they give me a lot of money considering they've done nothing wrong," end quote. Procedural history. Rather than negotiate, Jenner sued 3 days after the order's issuance and sought a temporary restraining order the same day. The complaint challenged the executive order in its entirety and raised 13 counts, violations of First Amendment 6 times over, violations of due process thrice over, a violation of equal protection component of the Fifth Amendment, violations of the Fifth and Sixth Amendments protections of the right to counsel, and a violation of separation of powers. The TRO motion raised the same sweeping arguments but sought narrower relief, more tailored to Jenner's immediate harm, asking the court to temporarily enjoin sections 1, 3, and 5 of the order. Following a hearing held the same day, the court largely obliged. The court concluded that Jenner's challenge would likely succeed because the order retaliates against Jenner for its protected speech and constitutes unconstitutional viewpoint discrimination problems that were magnified by the order's additional Fifth and Sixth Amendment deficiencies, reflected in its attempt to undermine the essential role that lawyers play in our policy. It then found that Jenner faced imminent and irreparable harm. The order's economic impacts threatened the existence of the firm, and its constitutional impacts deprived Jenner of its First Amendment freedom. And the public interest and balance of equities easily favored relief, as the legal profession as a whole was watching and wondering whether the federal government would turn its unwanted attention to them next. Accordingly, the court entered a TRO restraining the defendants from enforcing sections 3 or 5 of the executive order and from using the statements in section 1 to punish Jenner, its clients, or employees. By consent of the parties, the TRO has remained in place pending final judgment. The defendants then moved to dismiss, while the plaintiffs moved for summary judgment and a permanent injunction. The court held a hearing April 28th and now resolves the competing dispositive motions. Standards. The defendants filed a motion to dismiss. Jenner filed a motion for summary judgment. The traditional difference between these two types of motions is the discovery that follows the one and enables the other. Summary judgment is premature unless all parties have had a full opportunity to conduct discovery. Here, though, both parties agree that they do not anticipate needing discovery. The Citation is to the status report, and the defendant submitted evidence of their own in response to Jenner's motion for summary judgment here. Since the defendants have responded to the submission of exhibits with evidence of their own and had an opportunity to either conduct discovery or come forward with additional evidence to the extent they wished, the court will construe the defendant's motion to dismiss as one for summary judgment. That leaves the parties with dueling cross motions for summary judgment. In that posture, each party receives the benefit of favorable factual inferences for purposes of the other party's motion. Summary judgment is appropriate if there's no genuine issue as to any material fact, and either movement is entitled to judgment as a matter of law. If it prevails, Jenner seeks a declaratory judgment and permanent injunction. In addition to a meritorious case, securing a permanent injunction requires Jenner to have one, irreparable injury that it will suffer absent injunctive relief, two, no available remedy at law, such as monetary damages, adequate to compensate its injury, and three, an upper hand considering the balance of hardships and the public interest. Citing case law. Here's the analysis here. Number one, the executive order violates Jenner's First Amendment rights. The challenged executive order targets Jenner for what it has said and thereby attempts to dampen what it might say. That's unconstitutional under any view of the First Amendment. But two additional features of this order magnify its offensiveness to freedoms the First Amendment guarantees. Its viewpoint discrimination and its targeting of lawyers in particular, and none of the order's sections can be salvaged by the executive branch's discretion in guarding the nation's secret, in contracting, in investigating discrimination, or in landlording and hiring. A, the executive order retaliates for and seeks to silence Jenner's protected speech. Jenner's primary claim and its most straightforward winner is the First Amendment retaliation claim. To prevail, Jenner must show 1, that it engaged in protected conduct, 2, that the government took some retaliatory action sufficient to deter a person of ordinary firmness in a plaintiff's position from speaking again, and 3, that there exists a causal link between the exercise of a constitutional right and the adverse action taken against him. At prong 3, the improper motive must be a but-for cause of the government action, meaning that the adverse action would not have been taken absent the retaliatory motive. The first two prongs are easy. Begin with an area of significant agreement of the activity for which Section 1 denounces Jenner. Nearly all enjoys robust First Amendment protection. This elementary and unchallenged point need not occupy much space. Ooh, that's a harsh burn. Jenner's partisan representations to achieve political ends is another way of saying courtroom advocacy on behalf of its chosen causes. That is the very core of the First Amendment's protection of litigation as a vehicle for effective political expression and association. The same goes for Jenner's pro bono representation of transgender people and asylum seekers. Quoting here, refusal to accept the biological reality of SEX and obstruction of efforts to prevent illegal aliens from committing horrific crimes and trafficking DRUGSs. Whether best captured by the freedom of speech, petition, or assembly, this is precisely the sort of vigorous advocacy against governmental intrusion that has long been made that has long made lawyerdom proud. As for Jenner's employment of Weissman, it's evidently Weissman's criticisms of the president and participation in legitimate investigation of election interference that drew presidential disdain, and it is Jenner's erstwhile association with Weissman that extended that disdain to the firm. But Weissman's activity falls easily within the First Amendment's muscular protection for criticism of government and public officials, citing New York Times versus Sullivan. And The criticism can no more bring Jenner into the administration's crosshairs than it can bring Weissman himself into the administration's crosshairs. Citing case law, quote, government cannot constitutionally punish individual or group advocacy of any position unless it amounts to incitement to a lawless action. That's very important piece of precedent here. The second prong poses no more difficulty, usually figuring out whether retaliation would chill a speaker of ordinary firmness, and ascertaining just how much a speaker would have to trim her advocacy to avoid reprisal requires some guesswork. Footnote 7 here bumps us down to another case. That said, the bar is not a high one, citing the Tao case. Quote, as the Supreme Court has noted, the First Amendment protects government employees from even an act of retaliation as trivial as failing to hold a birthday party for a public employee when intended to punish her for exercising her free speech rights. Quoting a Republican Party of Illinois case. Not here. The serial executive orders targeting law firms have produced something of an organic experiment, control group in all, for how firms react to the orders and how they might escape them. Over the course of that experiment, several firms of presumably ordinary firmness have folded rather than face similar executive orders. Indeed, it appears to take extraordinary firmness to resist. So a lot of firm going on here. And the experiment has shown what folding entails, compromising speech. Here, so second, Paul Weiss, executive order. Paul Weiss has agreed to adopt a policy of political neutrality, accept pro bono matters representing the full political spectrum, and dedicate $40 million in pro bono services to causes of which the president approves. The third prong, the causal link between the exercise of a constitutional right and the adverse action, requires more analysis. Section 1 of the order leaves no question that there is some causal link. As to that, section proudly identifies Jenner's protected activity as a reason, indeed the primary reason, Jenner has earned the president's disdain, and the defendants make no attempt to dispel the impression that Section 1 leaves, as they, in fact, double down on Section 1's accusations in their briefing, quoting defendants highlighting that Jenner does not and cannot seriously contest that it's providing pro bono representation in a challenge to the president's executive order designed to protect children from chemical and surgical mutilation, or that it hosted an event interviewing Weissman. To prevail on its retaliation claim, however, Jenner must show that not only that its speech was a cause for the executive order, but that it was a but-for cause. That requires showing that the order would not have been issued absent the retaliatory motive. If the defendants can point to unprotected activity that would have justified the same actions, then the fact finder at trial, not the court at summary judgment, would have to resolve that credibility dispute. This final showing is complicated by the one aspect of Section 1's accusations the First Amendment leaves unprotected: discrimination. So the defendants attempt to save Section 3 and 4 of their order by clinging to Jenner's supposedly discriminatory employment practices, insisting that they would have taken the steps those sections direct, even absent any retaliatory motive. We have footnote 8 here. I will be doing a Q&A, everyone, after we finish our First Amendment section here. This is a generous construction of the defendant's argument. Apparently not eager to face a jury, they disclaim any genuine issues of material fact that would necessitate a trial. So they style most of this argument not as a factual dispute, but as a legal argument that the First Amendment disappears or retreats to more rationality review so long as the defendants identify any non-retaliatory motive at all, leaving no need to assess the retaliatory motive. All right. And they attempt to save Section 2, security clearance suspension by vague reference to national security, another facially legitimate motive. These are doubtful propositions given the order's persistent emphasis on gender speech and comparatively scanty treatment of discrimination and security concerns. But this is a summary judgment, and the court is not a jury. It cannot weigh competing motives via word count. Instead, the court must determine whether gender prevails as a matter of law, so it will investigate whether non-retaliatory grounds are in fact sufficient to provoke the adverse consequences prescribed by any of the order's sections. Keep in mind, however, that this is no run-of-the-mill retaliation case for several reasons bearing mention. Although retaliation connotes retrospective punishment, its greatest danger lies in its prospective silencing effect. The reason why retaliation offends the Constitution is that it threatens to inhibit exercise of the protected right. And quoting case law, that forward-looking threat looms especially large here, not only for other law firms, but Jenner itself. The administration has shown a repeated willingness to haggle, sending the message loud and clear that Jenner can spare itself if it compromises its speech. So whereas retaliation usually punishes once and moves along, the retaliation here is ongoing and avoidable. In this context, retaliation amounts to something akin to impermissible scheme of informal censorship that arises when government actors use the threat of invoking legal sanctions and other means of coercion to achieve the suppression of disfavored speech. Such threats present an especially harmful sort of retaliation, analogous to, though less absolute than, the prior restraints that are the most serious and least tolerable of First Amendment violations. All right, and then one more bit here, everyone. I will go ahead and turn on the questions. Then there's the fact that we deal here with lawyers. In this context, the forward-looking censorship scheme threatens not only the First Amendment, but also the right to counsel's promise of a conflict-free attorney devoted solely to the interests of his client. A firm fearing or laboring under an order like this one feels pressure to avoid arguments and clients the administration disdains in the hopes of escaping government-imposed disabilities. Meanwhile, a firm that has acceded to the administration's demand by cutting a deal feels the same pressure to retain the president's ongoing approval. Citing an amici curiae brief here, either way, the order pits firm loyalty to client interests against competing interests pleasing the president. The Constitution shields clients from lawyers caught in such a struggle to serve two masters. That this order only targets lawyers magnifies its threat to the Constitution in other ways too. Lawyers and the firms they comprise are not, it goes without saying, immune from the legitimate exercise of state power. But neither is the Constitution blind to lawyers' importance in upholding our democracy. Indeed, at least 4 constitutional amendments afford counsel specific protection in view of the foundational nature of the right to counsel. This is because the right to sue and defend in the courts is the right conservative of all other rights and lies at the foundation of orderly government. Our society has entrusted lawyers with something of a monopoly on the exercise of its foundational right, on translating real-world harm into courtroom argument. Sometimes they live up to that trust, sometimes they don't. But in all events, their independence is essential, lest they shrink into nothing more than parrots of the views of whatever group wields governmental power at the moment. All right, and I'll go ahead and stop there, everybody. That's the end of our First Amendment argument. He does go into the Fifth and Sixth Amendment and then the other counts. But for today, I wanted to really talk about that First Amendment question. So we go ahead and turn on comments. There we go. There we are. All right. So that gives you a pretty good start into this case. Hello, everybody. Hello, upgrade. Let me make sure I push this up enough so everyone can see comments here. Hello. Good to see everybody. It is a lot. It is a lot. Yep. And that's just the first little piece here. That's just that First Amendment argument. Good afternoon. Hello. Hello. Hello, Rika, Miss Rachel. The attack on the legal field's insane. Well, exactly. Exactly. I mean, it really is. And if you can, what was it? Was it Shakespeare that said the first thing you need to do is go after the lawyers, right? I snorted at masculine. There's a lot of, there's a lot of that. I'm not sure if it's this judge that's a little old school or just there's just so much of that, but we'll see that a lot throughout a lot of our cases. Oh, your sister did. Oh, interesting. Legal field itself. Is it the first summary judgment? No. So our first summary judgment, and I'm looking here at my wall, we've got Grunman v. Trump. Here was our first summary judgment, and then the Perkins Coie case is Coie is the second one, but that would be our first law firm summary judgment. What judge is this? Well, let's Judge John Bates, so U.S. District Judge out of D.C. here. And also, motion for summary judgment is a final action here by the court, right? And of course, it can be appealed. All final actions can be. This would not then be an interlocutory appeal. This would just be a regular appeal. New nails. Yep. So we have a lot of motions for summary judgments that are coming into play now with all of these lawsuits. We're moving past the initial complaint phase of a lot of these lawsuits. Again, we're around that 250 number. And so now that we're working through the preliminary injunction, temporary restraining orders, or pausing the harm that is being put forth by the plaintiffs, now we will start to get into discovery, and we're already starting to see discovery questions where the government is saying we're not going to give you any information. We don't have to give you information, and now those kinds of questions are being appealed. And in fact, there was one that went to the Supreme Court yesterday, where the Supreme Court's like, you need to pause the case while we get all of this sorted out. So we are definitely moving through the process. I think this was a good judgment, the summary judgment here. I don't think it's necessary for this to go to a full trial situation when the questions are just so simple. The questions and answers are so simple. And again, we have a situation with attorneys where you file in good faith. You file on your reputation saying, I really believe that we've got a case here. Ethically, that's what we're supposed to do. But we're in this interesting place now where the Department of Justice just doesn't ask that question anymore. The ethics for the DOJ attorneys are just, missing. So they will just file whatever they're told to file is kind of what's happening here. So unfortunately, Coie, thank you. I knew I was saying it incorrectly. What does Jenner do if they still find the government is shutting them out? So at this point, since they've won, the executive order, well, first, there's going to need to be something done with the executive order. It'll need to be pulled, or it's been ruled unconstitutional. So if anyone's trying to go forward on it, then that would open the door to future lawsuits. He seems solid. Okay, well, good. I've yet, in all honesty, everyone, again, there's around 250 cases going on here, and it's all over the country. I've yet to find a judge in any of these cases that I've been suspicious of, quite frankly. I mean, even in Texas, everybody, like the judges all seem okay. Do they all rule the way that I think they should rule? No, they don't. That's normal. But I have not found a judge that has been questionable yet. So that is always a possibility as we go through the system, because people are people. Some are good, some are not good. But so far I've not seen it. National, okay. Proud to say we filed it. Oh, good. Oh, we love that. Oh, that's fantastic. This case, I tell you what, this case has had some amazing filings in it. I mean, this firm just came out swinging. They were not even playing around. They came out with their motions and their filings, and they just like flooded the docket and said, this is a bunch of baloney. And I just love that. I mean, that's what you do, right? I mean, that's what lawyers are supposed to do. We're there to fight, and you got to believe in your cause. That's the other thing too, right? I kind of look at it like, I don't know, what's the, like back in the old days, right? When you have a very loyal military fighting for you. And I mean old days, like let's go back to, like kilt times. You're so loyal to your boss. You're like, oh, I believe in this. And so you go and fight, right? But then you don't have any soldiers anymore, right? And so then you hire the mercenaries and you bring them in, and they're just there for the money. So their heart's not really in it. And I feel like that's kind of what the DOJ is right now. They're mercenaries trying to get a paycheck, right? And so it's like, well, whatever happens, happens. We'll keep moving forward. But at the end of the day, there's really not a loyalty to the Constitution that kind of makes them honorable. I know, weird, right? I don't know, kilt times. What am I thinking of? Outlander, I think. Sorry, everybody. I was like, what's Jamie wearing? Yeah, so... Yeah, they're mercenaries. They're hired thugs, legally. So yeah. So again, and meanwhile, these firms like Jenner and other firms of filing. I mean, there were over 500 law firms that were coming in and trying to help both Perkins and Jenner here, saying, "Wow, this is." Rubbish. But for the rest of us, like we're in it to protect the Constitution. Like that's where my oath went. It doesn't matter what you pay me. If I have no honor, what am I going to spend the money on? Right? Like I've got no honor. I'm gonna go buy extra, cars. Yippee! Like whatever. You can't look at yourself in the mirror. So that's what I think is so great here is that although many have fallen here of these firms where they've just capitulated, which just shows they're cowards. And it's again the opposite of how attorneys are. Like we fight stuff, but we're seeing who they really are. So they're kind of crumbling. Could they lose their licenses? Yes, they certainly could. And that's definitely in the cards. The only thing is it takes time. It takes some time to go through the whole process. I like to give the example of Eastman, who was one of the attorneys involved in the shenanigans that went on. Here we go. I'm going to warn you. I've got a picture, okay? I'll try to warn him before I put the picture up. So let's see. Here we go. This fella right here, all right? He's the constitutional expert, blah, blah, blah. And he just lost his license for all of his participation. So it can take a really long time, years, for this kind of stuff to actually go through the whole process. So that's kind of a bummer piece, but it still happens. Yep, Shannon, exactly. Firms that crumbled are losing clients and partners. Oh, absolutely. I mean, again, right? I mean, that's, so like, this is America. Like, I just keep thinking that to myself. I'm like, this is America. What are you doing? Crazy people. Because we're really all the way back to the beginning. Now, a lot of people probably didn't realize this, but if you go back and you look up the true history of the revolution in this country, most of the people who were, the rich people living the good life, they didn't want to break free from King George. They're like, we don't care. We like him. We're, England's cool. We're all like, wearing wigs and stuff. And that's the greatest thing ever because we're rich and happy. And they didn't want to break free, right? So it was the rebels that came in and was like, this isn't right. They're taking away basic freedoms and basic things here. They're going into your houses and doing very awful things. Like, we're done. Meanwhile, again, a lot of the aristocrats were like, well, blah, blah, that's where my blah, blah. So it's the same kind of fight here. We have a fight for independence. And although right now we're fighting against the red hats, the red hats are like, we have someone, very King George like, actually, if you think about it, there are a lot of similarities between King George and, the Trump fella. There's a lot of similarities, but they're like, look, this is what we want. We want to have this. And others are like, no, this isn't what we're about here. We decided we didn't want to do a king monarchy situation. And so we're not going to. And that's the fight that started. And that's the fight that we're there again, fighting. That's my soapbox. That's where I've been standing. No, we're the revolution's here, and they certainly did not win. They have not won at this point. We don't know who's won. We don't know who's won because we're in the middle of the war right now. And the war, again, and I've said this before, we are in a civil war. The war is in the courts. That's where we're fighting. We're not on the battlefields. We're in the courts. And one case at a time, one battle at a time. And it's, we go back and forth and we see who's going to win at the end. We'll count up and see who's left standing at the end of this. Yes. I mean, and it's, I think this happens a lot in the US, is that we go through this cycle of like, la, 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 we don't really pay attention. And then something breaks and we're like, oh dear, that broke. We got to fix that. Let's go fix that and then make it so it doesn't break again. That's kind of like that's our modus operandi in this country. We just do it over and over and over again. Oh, thanks, Nani. Stipulations can ignore lower court injunction. That's not actually what it says. And there's a lot of, let's talk about that for a minute, everybody. There is a huge misunderstanding going on about the contempt stuff, all right, in the bill. Let's clarify that so you can pass it on to your friends and family, all right? The piece that's being proposed in the bill is saying that if judges don't put a bond on a preliminary injunction or TROs, temporary restraining orders, when the government's involved, if they don't put a bond in place when they order it, then they cannot use the money given to them by the federal government in order to enforce it. All right? So that's not cool. You shouldn't have put that in your budget bill. That's kind of like a dingleberry moment. But on the other hand, nowhere in there does it say, well, and now all the courts belong to the president. That's not true. I'm not sure who's saying that out there. Or, this is the end of the judicial branch. What are you talking about? That's crazy talk. That's not at all what it says. Do I support it? No. Is it constitutional? No. Does it go against the rules? Yes. Is it really crappy? Yes. But does it end our entire country and give all the powers of the court to the president? No, it does not. So let's get that clarified. Right. Lower class has the courts. Well, it's interesting because our classes are not as clear cut as they have been or are in other countries. Our classes are a bit more mixed because our whole country is so mixed. But I think that's an important piece. They can't enforce it. Then who's gonna stop? So I don't even know what that means. I don't even know what that means. Yeah, exactly. I don't even know what that means. And our judges are incredibly intelligent. I mean, so they're like, we just choose to not put a bond. We can because, we want to, but we're not required to put a bond. So, like, if you want to require a bond, whatever, but you're not going to be able to go retroactively on open cases here and dink around with stuff. Can you please review DOJ VV, a Palestine guy? Do you mean Khalil Or, I mean, you're going to have to narrow it down. There are a lot of those kinds of guys there. Josh, great question. I look at all cases. I focus a lot on federal cases because it just reaches a wider audience, like it applies to more people because people that are coming and hanging out are just, from all different states and jurisdictions. So as long as the federal and the states courts decisions are close enough to each other, but there are some significant differences, but I do like to use the federal rules of evidence, federal rules of civil procedure, criminal procedure. It just makes it easier for people to understand. If contempt is totally proven, who's going to enforce it? So that's a great question. Let's ask the chat. All right, chat. Let's say hypothetically, you have an DUI, all right? And you have to pay some huge fines. And the fines have been due for 5 months and you aren't going to pay. So the judge finds you in contempt of court for not paying your fines. Who then is coming for you? Who's going to come for you in order to enforce that court order? Right. Who enforces that order? Who makes you pay? Who makes you pay? Marshals. Okay, county sheriff. Anyone the judge says, right? Sheriff, right. So the court, right. Well, I mean, the court, like the judge isn't coming down off the bench and being like, give us your cash. But yeah, local authorities, right. Exactly, everybody. You got it. So you can have the anybody who is law enforcement or able to enforce a law can go and say, hey, you've got a contempt order against you. I'm arresting you. There's a bench warrant, right? Anybody can. So anyone who can enforce a court order can go after whomever is found in contempt at the federal level as well. Now you might say, well, the DOJ and the marshals are, executive, blah, 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 blah. But again, the oath's to the Constitution. And there are a lot of people that took that oath to the Constitution. And I'm sure there are many people who'd be happy to execute these warrants. Transfers to small claims with garnishment. Oh, that's a great point too. Yeah, if we're just going for the money, if we're one for the money, two for the show, but we're one for the money, absolutely. Good point. Upgrade. Good point. Who's getting the federal marshals, executive or judicial? Well, the thing is, all right, if there's a marriage divorce situation, right, the kids can be ordered one way or the other. But if your kids are independent, they may agree or not agree. So same with the marshals. Like you can say, well, the executive orders the marshals around because it's a federal enforcement piece, like the FBI. But then on the other hand, it's like, well, they're actually people too. So if the marshals are ordered to do something that goes against the constitutional, each individual marshal will have to make that choice. Do you want to do that or not? And we can see what happens because in the Department of Justice, people walked away. They're like, I'm not going to do this. It's unethical. I feel that will be the same situation. A new side hustle. Go for it, Chris. Go for it. Absolutely. Why haven't the judge acted? Assigned someone to do the job. So, Lisa, the interesting thing, well, unfortunately, here's the deal. In the legal world, these judges are, running at 150%. Our system works so carefully so that every single right and rule is used and not violated. Our judges are busting their keisters on this. I mean, the fact that this was filed, I think this was filed in March, and we're already at summary judgment in May. I mean, that's quick. These judges are going fast. And although it seems like it's super slow, in the legal world, this is expedited. I mean, they're working hard. The process just takes a really long time because there are so many rules. March 25th. Okay, thank you so much. Yeah, so in 2 months, we've got a summary judgment here on a major case involving a huge executive order. I mean, this was quick. This was quick legally. This was pretty quick. So that's it certainly is in reality, in the real world, it certainly is slow. But in the legal world, we have a different clock. It's like, island time is different than real time. So this is legal time versus real time. It is quick. Yeah. I mean, it's quick. But unless, you're in the weeds of the legal field and you're working with these motions and you're waiting on orders, there's no way that you would know that, right? There's no way that you would know that 2 months to get a summary judgment is fast. That seems like it's taking forever, right? It seems that way unless you're actually in the thick of it. I do put them up, Connor, I do put them up. Very persuasive when you look at cases. I don't, Josh. And interesting. I don't. I like to push them aside because I think that they've got a role to play in the foundation piece. But then I feel like, you got to kind of push them aside. You got to deal with what's going on in the moment because sometimes we just, have to work around with what we've got. But most people don't know that. Rocket Docket. Yes, this will be up on the Tube of You. Yes, so I was not up on the Tube of You this past Tuesday. I go do live streams on Tuesday nights, over on the Tube. This past Tuesday we had like a breaking news moment, so I was over here. But file a case to get reimbursement for costs. Good question. They probably could. I doubt they will. That's like the least of their concerns. Yes. Oh my gosh, Josh, I tell you what, we are going into the weeds of language when it comes to this administration and exactly what each piece of the statutory construction is for every single word and the intent for and against it. Like, it's really getting ridiculous and it's at a level I've never seen before. I think it's important to pull those elements in, but when you're trying to use it as a weapon in order to win in bad faith, that is very disturbing to me. That's very upsetting. In my humble opinion, how much do you think judges in general are worried about becoming irrelevant due to? I think judges realize how important. They realize they're called right now. The judges are stepping up to the plate. They're usually, in the background. People don't really see them, but the amount of work that they do constantly is just never ending. And there's no acknowledgement unless you're mad, typically. But I think our judges realize at this point, they're the ultimate protectors of the Constitution, right? So that's their world. That's their every day when they wake up, they have their coffee and they're like, okay, let's go, make sure that Constitution's working. That's what they do every day. And so I think they recognize that in this moment. Yes, I saw that. And, too, I know there's a lot of firings, removals, displacement, dismantlings of people that in positions that the administration doesn't like. And yeah, I think that's an absolute abuse of discretion. It's going to take years in order to get that sorted out. That's kind of the nature of when you get this kind of a person into the position where his minions have power. That's just kind of how it goes, unfortunately. But I don't think it will be the end. I think this will, we're sustaining a lot of damage. I think we're sustaining huge amounts of damage. But, one thing that I think people forget about when it comes to America or comes to the US is that we're rebuilders. We rebuild everything from the beginning to the end. And if you think about our indigenous peoples, they had to rebuild. If you think about, the original colonists over here rebuilding their lives, and that's what we do here. And so there's some damage we're sustaining. And then once the damage finishes, then we rebuild. So that's kind of what we're looking at here. Huge hit. Yep, I agree. How many large law firms have given in? Is anyone tracking? Great question. I don't know. And I don't know about that. Constantly having to re-pick up. True, and it might seem that way. It might seem that way, but it also is how you get fresh, new things going, right? So in the way I like to look at it, from a political science point of view, I guess, and I like to compare the US to China in some ways. If you go to China, right, if you look at the history there, like China, if they go back forever, they can read, understand the language. I mean, the ancient dynasty pieces of China, that history is just amazing. It's just absolutely amazing. And I just absolutely adore it, right? So they've got this huge history to their nationality, to their whole culture. And then you look to the United States, like we're a couple hundred years old, this country is. I mean, I'm not talking about our indigenous, but if you look, and we continue to reinvent ourselves over and over and over again in the country. So we don't have that kind of ancient, beautiful history that China has. But that also means China has a bit of a struggle stepping away from that history and coming into what's new and what needs to change and how to go forward with different ideas and different ways of doing things. If you look, I mean, they struggle with that because they have all of this ancient history and they rely on that so heavily, which, I'm not saying it's right or wrong. I'm just saying it's difficult for them. Meanwhile, in the US, we just don't have that. And so, when we build it up, we knock it down, we build it up better. We knock it down again, we build it up better. So it's this constant cycle of new and better each time that really kind of defines our country. And again, and then in China, the struggles sometimes can really be, coming up into where we are today in 2025, as opposed to, what we did, however many years ago. I always feel like the United States, we're coming up on 250 years. And it's like China can hold their breath for 250 years, right? That's how ancient they are. They're like, hold on, I'll just hold my breath for the length that your country's been here. So, there's good and bad. There's good and bad with both of those. But, I don't think necessarily that it's a symbol of trouble for either. I think it's just a different way that things go forward. Right. Mm-hmm. Yep. Yeah, I think we've had a few shifts over time. Yeah, I think we definitely have a few shifts, and have since the beginning. So, I think that's because, again, we in this country we don't just grab onto something forever. It's always changing. There's just something that's changing. We just don't have that perspective on maintaining history and continuing with everything the way that it's been, that, another country like China has, with that kind of beautiful history. China would agree that they think in advance. Yes, exactly. And I'm not trying to say there's anything wrong with that, but it certainly is different. It certainly is a different way of doing things than what we're doing here specifically. Right. And the other thing too is that we're fighters over here. This whole country, like everybody, this country was fighting before, other people even came here. So it's almost like we pick fights with each other. There's a lot of fighting going on. And so I think if we hit a lull, someone's like, well, let's just throw a little gasoline and, get it going again. We just have to do something about it. We just have to do that. No, I think we still fight. And I say that because of our legal community. I mean, it's an adversarial process. And if you're in court, in criminal, civil, it doesn't matter, administrative. Like you wake up every day and you go and you fight. And that's why, again, it's like the Civil War occurring in the courts right now. Like that's where the fight is. Yes, we will see. We will see. Have I seen the Harvard case? Yes, I've been reading through that actually. The it's Gosh, I tell you what, you want to read an incredibly well written complaint, grab that one. It's very good. It's over 70 pages and incredibly well written. We'll have pain, but we'll come. I absolutely do, Lisa. I absolutely do. And that's what we do here. That's what we do here. We make bad choices. We break things down, but then we rebuild. And I think that will absolutely be where we're at again. Adrenaline junkies. I think that's good. I think that's accurate. Oh, real life works. Oh, absolutely. Yeah, we rebuild and we rebuild better. And that's, again, right? I mean, that's how we started. That's how, and again, I say we very openly here because I am not dismissing our indigenous peoples as well. All right. There's a rebuilding element to our entire country, no matter if you were here when others came or you were the others that came. I think both have this rebuilding element to them in this country in order to survive. So absolutely, I think. Oh, skeptic, I understand. These are some dark times. These are some dark times, but again, you just keep walking through it. We'll defeat the red hats as well. Absolutely. And ultimately, if you think about it, sometimes it's good to remember like what happens afterwards, right? What happens afterwards when you have to go and you have to look at that person and say, look at all the damage that's been done here. From choices that you made. And that's something else that I think will truly be the legacy here is how the people involved in this, again, historically, how they will still be, who they are. And that's something that everyone will have to kind of deal with. The afterwards, yep, exactly. Absolutely a light at the end of the tunnel. And I truly, truly do believe that. I truly, truly believe that. Yeah. And again, it's because, we're fighters. We're fighters here. And sometimes we're scrappers, not just fighters, but, street fighters. Like, I'm not talking about, oh, my epee, no. I mean, we're the brass knuckles. Let's do this. So I think that's kind of, we can go both ways, but we're scrappers. Oh my gosh. Yeah, exactly. So I think we definitely, you think the course will hold? I do. I think they're, and again, this is behind the scenes and everything's been crazy. We've kind of foreseen the madness of Congress that was on its way. And we also foreseen, and we had a playbook on what the executive branch wanted to do. So, although painful and hard to watch, it's not like, ooh, well, that's weird. Like, oh my gosh, like, no, we had a pretty good idea. This was a coming. Yes, the fair elections, that's absolutely key. And to that, I am going to be waiting to see what happens. I think as we get closer to November, we passed several federal laws after what happened in the prior election. So a lot of things were put into place to kind of take care of the problems that we had. So there were a lot of protections in place. So I will be interested to see what happens when it comes to November. Right. And exactly. And, that's the change. Change is painful. And this is very painful. Yes, cautiously optimistic. and realistically optimistic. I mean, it's again, there's some dark days still ahead of us, as Sotomayor would say, but I don't think it's something that we can't overcome, honestly. And because again, that's what we do here. That's what it is to be an American. You overcome those challenges and you come out the other side. And I truly believe that. Yes, yeah. Yeah, but not Delulu. Well, there's plenty of other Delulus out there. Oh my gosh. That's very, very important. Right, right. I agree. Yeah, and there's a lot of things at play here, especially because they need to have, one of the art of war pieces is to pick a group to go after, right? And then get everyone to rally around you and say, all right, we can all come together because of this one group. And so I think right now we all know who is the group that they're rallying around taking over. And then the harshness and the justifications then are like, well, we had to do what we had to do because of this bad group. So I think that continues to play in this situation. Yes, yes, I think we will. I think we will. But again, everyone, we just keep going forward. We remember how the history here. And again, I'm not just talking about the history of the United States. I'm talking about the history of this full country here. You take a look at that and you'll see again, we just keep going forward, just keep one foot in front of the other. Yes. So, but with that, everyone, I'm noticing the time. So I will go ahead and say fare thee well for today. Thank you all for coming and hanging out with me. I did want to, again, have those comments off so that I could read a little bit here. Amendments to the Constitution to stop. Eventually I do. I don't think we're anywhere near that right now because of what's going on in Congress. But I think, yes, I think this will absolutely be the catalyst to put some things in place to fix basically Article 2, in my opinion, and make sure to bump up the power in Article 1. I think we'll see that. We'll definitely see that. So it morphed into therapy. That's right, everyone. Write it down in your journal. So take care, everybody. I will, as always, be over on the tube on Tuesdays. But other than that, I will be doing some pop-up lives here. We've got a lot of stuff going on. So take care of yourselves, everybody. And I will catch you all at a later time.